Okay, well, we have over 300 people on the call today. So hi, everybody, and welcome to our discussion on the future of CVAs. Evolution or revolution, you decide. I'm Christina Fitzgerald. I'm a partner at Edwin Coe, specialising in restructuring and insolvency. Today, I'll be acting as your chair or perhaps the referee. We'll see how we get on. We'd like to explore some of the topical issues around CVAs and to hear some insightful commentary from those with real legal and practical knowledge. So let me introduce the panel. Firstly, we have Scott Murdoch, the Managing Director of CWM, a leading international independent retail property consultancy in the UK, which focuses on the retail, restaurant and leisure sectors. Next, we have Ian Caulfield and Phil Reynolds, partners with FRP Advisory, and they have been involved in many of the high-profile CVAs over the last year or so. We have three contributors from Hare Court, Hare Court. We have Tom Poole QC, we have Rowan Pennington-Benton, and we have Ben Channer. And they've been at the coalface of the legal adaptation of these processes through the courts. And last but not least, we have Shams Raymond, a partner at Edwin Coe, who specialises in property and trust litigation. So let's begin. Could I invite Phil and Shams, please, to join the debate? So I want to talk about the early days and the role that CVAs played. So my first question is for Phil. Why do tenants find CVAs attractive? Why do they pursue them, Phil?
Well, thank you for that, Christina. Well, first thing I would say is really it shouldn't be forgotten that the CVA is still an insolvency procedure. So we do have a number of clients approach us who are quite clearly solvent, and it's probably not for them. And it really shouldn't be entered into lightly. But a CVA can provide the best mechanic to enable a company to continue under its current control or ownership, or to facilitate new ownership to come in, and vitally enable the restructuring its debts to deliver a viable platform to go forward. A CVA can typically be used to obviously exit from unsustainable sites and rebase rent on other sites to more supportable market levels. One thing might be quite interesting with benefit the new moratorium procedure, for example, is whether we will see more CVAs actually extended into restructuring the trade creditor base as well, which would obviously help assuage some of the concerns that landlords in particular have about how CVAs are being used. One of the other key real advantages of the CVA is, as well as obviously dealing with your real estate aspects, you can also use Redundancy Payments Office to manage the redundancy cost element. So effectively dealing with two of the largest costs of those type of businesses. Some of the other key advantages really from tenants in terms of the CVA is it avoids some of that commercial and reputational impact of an administration. Couple other bits I'd probably say on that is really the ability to cram down dissenting creditors is often cited as one of the key advantages of a CVA. In practice, you're not going to launch a CVA unless you know you've got the vote in hand to achieve that, and the CVA really should be able to stand on its merits. The other bit I'd really add on is, clearly the CVA has been through a process of refinement and evolution since its implementation, and even with the current flurry of appeals against CVAs, a CVA can provide that certainty of outcome if constructed properly for the benefit of all stakeholders.
Thank you, Phil. Now, I'm very keen today to have a balanced discussion. And Shams, you act for a lot of commercial landlord clients. So let's have a shout out for the landlords. Why did landlords tend to dislike CVAs?
Yeah, thanks very much, Christina. So I think we've all seen really an evolution of CVAs and how they play out, and for landlords in particular, given at this time. The statutory moratorium under the Insolvency Act can restrict the landlord's ability to forfeit. Landlords can often get hamstrung or straddled with revised terms, including in respect of rent, which can be a turnover rent, as I'll come on to, and they were neither consulted nor agreed to those terms. On some of the CVAs we've seen, different premises are put into different categories, with the effect that the lower categories, C and D, the landlord may be presented with the option to terminate the company's lease, but then have no recourse in terms of any substantial dilapidations claim. And again, I can come back to that later, post-termination, which results in further losses for the landlord, landlord being compelled to undertake further substantial work before reletting and so on. It's also more difficult for smaller landlords to band together if they're less profitable, have less cash flow. It's much more challenging for them to band together and challenge CVAs, which are difficult and quite costly in themselves, and to satisfy the test of unfair prejudice or irregularity can be quite challenging. It's also not considered and automatically prejudicial to a CVA that the rent has been reduced. So again, turnover rents is not really ideal. You can't have a one-size-fits-all strategy, and that's caused lots of problems for different landlords, and doesn't work in all situations. So it really is a case of evolution.
Thank you, Shams. Could I invite Ian and Scott, please, to join the debate? Terrific. So in the early days, do you think tenants took advantage of the CVA framework? And I'll address that question to Ian.
Thanks, Christina, and good morning, everyone. I think, as Phil noted, CVAs are a powerful tool, but they're for restructuring and rehabilitation, but they're pretty young in their evolution. Although they've been around since '86, they weren't really used in any earnest until the late sort of noughties. So therefore, they're still evolving. I think the phrase "take advantage" potentially has a negative connotation to it, because clearly a corporate would want to take advantage of something they absolutely need. So with any great power, there is a risk that it's open to abuse. My challenge is whether that abuse is real or perceived, because it's pretty hard to establish which. If you consider a retailer that has historically outperformed all of its peers, but then faces a challenging period ahead, but its peers have already restructured through a CVA, then they're no longer facing a level playing field. So are they wrong to try and reduce their own cost base to level that playing field? Because ultimately they have a duty to their own shareholders and to their own suppliers as well. So it's a fine line between what is taking advantage and or an abuse of a restructuring. I think perhaps because a number of CVAs and high profile CVAs have failed or had repeated bites at the cherry, they've come under a lot of scrutiny, and again there could be a view that they're being abused. And obviously, we're not here to rehearse the reasons why CVAs fail, but one of the reasons is that because of the voting requirements to secure a CVA, quite often they are suboptimal. So one has to give away more to certain landlords or certain creditors to secure the votes. So therefore, of course, they subsequently fail because the business hasn't been restructured down to what it really needs to be. So there's a slightly vicious circle in this there, where there could be between perception and reality. But let's be clear, there will have been circumstances where they've been pushed and the abuse certainly may have taken place.
Thank you, Ian. Look, let's have some polls for the audience. Let's have the first poll. Do we think landlords have been poorly treated? We have a yes or a no. Okay, we have marginally in favour of the landlords. So let's have a look at the reasons behind this. Question, please, for Scott. Did landlords take an aggressive approach, do you think, which undermined a consensual solution? And
yes, Christina. Sorry.
Yeah. Has this adversarial approach undermined the success of CVAs?
Good morning, all. Thanks, Christina. Yes, I think unfortunately the answer is yes. There's been four phases that I've noticed with landlords' reaction pre and post pandemic. So it started off, I think, pre-COVID with a lack of understanding of what the insolvency process revolving around CVAs was all about. And there was a little bit of an ignorance to begin with, and therefore there was it wasn't so much aggressive, it was just a lack of understanding. Then when the pandemic hit, I think landlords became very adversarial, very aggressive. They could see this was going to be a major problem. They could see their valuations being hit enormously on their portfolios and shopping centres in particular. And they panicked, and they were under an awful lot of pressure from their boards and their shareholders. And so that resulted, sadly, consequently, in a fairly adversarial, sort of aggressive approach. Then I noticed that towards after the Coronavirus Act came out from the government guidelines, the British Property Federation's involvement, there was definitely a softening of landlords' views around the summer of last year, when they were working much more consensually and much more sort of supportively towards tenants trying to find a way to reach sort of amicable solutions. And then there was a further swing. The last swing became adversarial again, because most landlords, particularly the larger institutional landlords, employed and chose a specific sort of CVA specialist in their organisation to fight the good fight against all sort of CVAs, because they felt that far too many of them were happening and they were creating competitive advantage, and they fought very, very hard. So it was almost ups and downs through the process. They're now an awful lot more savvy about the process, as I mentioned. They have dedicated CVA specialists. They're much more collaborative. And they've now formed steering committees with other rivals, which is ironic, and has never happened in my sort of 30-odd year career, where you have arch rivals, especially the larger institutional landlords, forming collaborative steering committees, meeting offline, discussing whether a CVA is appropriate and sort of they should support it or not, and trying to help each other out. The irony of all of this is that because of lease term structures, because of the importance of certain tenants to certain landlords, lease expiry profiles, performance of the stores, each landlord has a different view. So even though they were collaborating with each other, what I found extraordinary was that they would then go to a voting procedure, and one would vote for and the other would vote against, because they've all had different sort of issues. So yes, I think, Christina, during the process, it's been a very interesting sort of full phase scenario, resulting ultimately in a quite an adversarial sort of landlord position.
Okay, you mentioned collaboration. Ian, have you seen the difference of treatment between UK and foreign landlords? Oh, you're on mute.
That's probably the audience muting me. No, very much so in my experience, actually, and reflecting on it, I wonder whether it's been even more so in the last 12 months or so during the pandemic. But it is understandable. If you think that an overseas landlord's come from a different insolvency and restructuring regime, has their own economic challenges. Quite often there's quite a big cultural difference between, for example, the East and Western business cultures in terms of long-term strategies over assets, and of course there are language barriers which can exacerbate time differences. If you're dealing with a Chinese or a Japanese landlord, just communication flow isn't always very efficient. But it's not just between, sort of domestic and foreign landlords. You see the differences as well. I mean, I think Scott's just alluded to whether you've got institutional or private landlords. It's interesting hearing what Scott's just said there, and this is live without thinking about it. I've seen big institutional landlords almost take a cookie cutter approach because it's another one on the pile. However, you can't compare a gym in a shopping centre to a hairdresser, to a retailer, to a pret-a-manger or a Cafe Nero. They're not comparable. So I think you have to fight hard to break through and explain the difference to a landlord. If you're then trying to do that with an overseas institutional or an overseas private landlord, you end up with a really interesting jigsaw piece that you have to try and fit together. And then, not that we want any sympathy, that's where Phil and I, and obviously Christina on the legal side, come into some challenges, because if you have a mixed pool of landlords with all these different dynamics, all on one estate, you have to try and navigate your way through this to get the voting, to get the right answer, and you have to be able to clearly explain the benefits. So it makes it very, very challenging, the difference of approach.
So really interesting, thank you for that. I've got a legal question that follows on from that, and perhaps I can invite Shams to join the debate. Shams, if businesses are open and trading, why shouldn't landlords be paid? And secondly, do you think we'll see further challenges to existing CVAs?
Yeah, that's very interesting, and I think there's a real compelling reason that if businesses are open and trading, then landlords should be paid to maintain their own businesses in turn. It's very difficult to see and forecast in terms of further challenges in the future. And I think it's important that CVAs are challenged from time to time to test the legal waters, and we've seen a number of these, and I think that will continue. There are obviously logistical difficulties and the costs associated and banding together, which I've alluded to, and it may be that only the worst affected can actually bring those challenges. But I think it'll be interesting to see whether the challenges continue. I think they should. The grounds for challenges are there for a reason, and those waters should be tested and continue to be tested. And of course, the other practical commercial point is landlords may be paid something under a CVA and may feel that something is better than nothing, as opposed to the tenant being going into administration and being wound up completely. So those are sort of commercial challenges, and there's a fine balancing act. So we will wait and see what happens.
Super, thanks, Shams. I'm now going to go to 3 Hare Court for some debate, and I'm going to ask Rowan to join me, please. Rowan, let's pretend that you're going to be the fortune teller and have a bit of a hedge. Look, the ban on winders is going to be lifted at the end of June, and we've got concerns about the backlog, about restrictions on enforcement. Perhaps you could enlighten us on how you see the future of that unravelling.
Yes, and gaze into my crystal ball. Well, I think the first thing to notice, I mean, some people seem to be of the view that there's already a backlog of petition applications in the court. And I mean, certainly that shouldn't be the case, because the legislation provides that winding up petitions based on statutory debts or statutory demands, rather, or winding up petitions during the moratorium period, which, as you say, is now extended to the end of June, should not be issuable. So if they are being issued, the court should be returning those. But I do know, I've heard certainly of some people who say, well, they've issued and not heard anything back. So the first thing I'd say is it's not safe to assume that if you haven't heard anything back, that your application, your petition is in a queue, and as soon as it hits the 1st of July, everything's going to kick back in again. I think if you haven't heard back, you probably want to be contacting the court or assuming that it's been binned and preparing a fresh application with your current IP. Getting together up-to-date evidence. I mean, I don't want to, everybody's professional on this call, so I don't want to be teaching people how to suck eggs, but basically get your statutory accounts, all the other evidence in order, get your application done, drafted, signed, but not sealed and delivered. And then as on the 1st of July, be one of the first people to put it in, because I think there will be a rush at that point, and it's going to be probably on a first come, first served basis. But I would also say, and not to encourage a flurry of people to try and meet what is obviously a very difficult test, but the ban on winding up petitions is not absolute. You can issue a winding up petition if you meet the COVID test, as it's inelegantly called. I accept, of course, it is a very difficult threshold. I think I don't want to go too deep into the cases, but there's one case by Judge Barber, who many people here will know, of course, very good judge, 2020, back in June last year, EWHC 1551, unhelpfully just called REA Company, so I'll give them the citation, but effectively, this is fairly early on in the process, and as many people know, the real problem is the statutory power to wind up is not engaged where it appears to the court that coronavirus had a financial effect on the company before the presentation of the petition. And the court in that case interpreted that as clearly intending to be a low threshold. The requirement is simply that a financial effect must be shown. It is not a requirement that the pandemic be shown to be the or even a cause of the company's insolvency. So I think that has discouraged, understandably so, people from trying to pursue petitions in circumstances where it's probably fairly straightforward for most companies to show that the COVID has had some kind of negative impact on their finances. However, in the usual way of things, I have to say, for my part, I think that's somewhat generous interpretation of the legislation. If you're sad enough to look at the debates on this legislation, which I'm afraid occasionally I am, I'm not entirely sure the government thought it was quite as generous as all of that. There's a more recent case called Newman and Templar, TEMPLAR, 2020 EWHC 3740. This is how to bring down the tone of any panel discussion by asking a barrister to give a talk and starts giving citation numbers. But I promise you, this is the second and the last case that I'll cite. And I only cite it because it's a more recent case from December last year. And I just get the impression that the courts are being perhaps a little bit less sympathetic than they were at the beginning of the pandemic. And in this case, the court, whilst accepting there was a low threshold of a financial impact on the company, nonetheless said that the company had an obligation to put forward evidence which gave rise to a genuine prima facie case on that point. It wasn't simply enough to say, well, look, it's bound to have had an effect. And in that case, the winding up petition was based on unpaid wages. So I do think there was a bit more sympathy there with the court for the petitioning creditors who basically just wanted to be paid. And I think you may find something, perhaps a similar level of sympathy in certain contexts with regards to landlords being paid, as Sham said, so that they can maintain their ongoing obligations. And the court in that case actually said that the test was not met and therefore the petition could proceed. So I do think, and I don't want to encourage a flood of people to start trying to do this because the threshold is still very high, but do have a careful think about whether actually genuinely there is evidence from the company on the other side saying, or you if you're defending one, the way you can genuinely show that there was an impact from COVID that is relevant to the petition date. It doesn't need to be a cause, but is relevant to it. So I think that covers your question and a bit more.
It does. Thank you, Rowan. I think let's have a poll. I feel a poll coming on.
Feel a poll coming on, goodness.
I feel a poll coming on. So this word tsunami is bandied around a lot. When the restrictions on wides are lifted, will there be a tsunami of insolvency work? There we go, 65-35. Okay. Let's hope that is the case. So look, let's have a think about the CVA and challenges to the doctrine of CVAs. And could I invite Ben from Hare Court to join us for this debate, please, Ben? Now, new look at the moment is a hot topic. We've all been considering the announcement, I think, next week and watching it very closely. Ben, perhaps you can outline new look decision and what the expectations are and how that impacts on the use of the CVA.
Yeah, absolutely, Christina. Thanks very much, and good morning, everybody. So a bit of background, as Christina says, we're hopefully getting the new look decision next week or thereabouts. Now that follows on from the new look CVA, which was approved at a meeting back in September last year. And at that point, it was said that the restructuring in line with the CVA was essential for the survival of its 500 stores and the jobs of the 12,000 employees that it has. But central to that restructuring was a switch or a an attempt at switching to a turnover rent, with landlords having to accept no rent for 3 years on 68 out of the 500 stores, and rents based on a percentage of sales for 402 stores, which the provisions allowed to be potentially as low as 2%. And on top of that, there were provisions for no changes to service charges. The supposed kickback, or the return that landlords were to get, were enhanced rights to take back stores to relet to other tenants if the landlords could obtain better terms. Now, of course, in the current climate, that's a very big if. So the turnover rent is the contentious main issue. It's a concept which is pitched as being the sharing of financial risk and reward between the landlord and the tenant, that's to a far greater extent than in commercial leases as they currently stand. And it's sold, I think, I'm sure everyone will generally be aware, and in line with what Scott was saying, it's a collaborative approach, or a purported collaborative approach between the tenants and the landlords. And indeed, the chief exec of New Look at the time of the CVA sold the turnover rent as aligning the risk and reward between landlord and tenant. And in simple terms, I think that's right as a concept, but obviously, given the current situation we're in on the high street, it's difficult to say what the potential rewards are likely to be. It's fairly obvious who that's likely to favour. I mean, historically, turnover rents haven't really been seen particularly frequently in the UK, I think it's fair to say. They're much more commonly encountered in the US and parts of Europe. And over here, they've been a relatively recent development. But that said, we're now starting to see them, as we do in the CVA, to be used quite widely and generally as non-essential retailers, I think, start to look at reducing property costs after what has obviously been a brutal year. Hopefully there's light at the end of the tunnel, but a brutal year and ongoing difficult situations due to the COVID-19 lockdown. And then, for instance, as well as New Look, last year we saw Clarks and Apricot Clothing and Ann Summers move to turnover rents under CVAs, but nothing quite like the scale that New Look has tried to embrace turnover rent. Now, when New Look announced their CVA, it was a decision that was almost immediately criticised by the British Property Federation, who said that right from the outset it didn't meet their best practice standards. Largely, I think, because there was this point taken, which I think is pretty fair. The CVA is designed to be a short-term fix as part of a wider rescue package to support businesses in genuine distress. And the British Property Federation said that the result of the New Look CVA clearly demonstrates the process is being weaponised, essentially, by businesses looking to rip up their leases permanently. And perhaps because of that, and more generally, it's unsurprising that there was then a legal challenge to New Look CVA that we're waiting the result of now, for landlords, including British Land, Trafford Centre, Land Securities, so obviously big landlords. And their argument being that the CVA, as the British Property Federation set out, fundamentally rewrites the leasing agreement, and the switch to payment in arrears is unfair. And what the landlords are pushing for through the legal case is that as a bare minimum they should be getting market rent, and anything under that effectively contravenes the entire principle of a CVA in terms of fairness. Now, I think it will be interesting to see, and there's been some fairly widespread discussion, I think, about this that I'm sure the audience will be aware, but it'll be interesting to see, I think, how the New Look CVA will be considered in terms of the turnover rent and fairness, following on from the Debenhams decision 2019, which at that point clarified to an extent how far CVA can or would have an effect on a commercial landlord. the reduction in the Debenham CVA wasn't lower. I think it's important to point out, it wasn't lower than the current market rent. And the judge found that to be an important feature in terms of fairness, really highlighting that contractual rent ought to be interfered with as little as possible to implement the purposes of CVA. And although we in Chambers tried to get the legal arguments for the parties advanced to the court, they kindly told us where to go. But I suspect that point about fairness being related to market rent really was a point that the landlords probably wanted to hammer home. But I think the effects are either way, and the implications of the New Look case are profound regardless of which way it's decided, and are likely to have pretty significant ramifications for the, I think it's fair to say, embattled retailers and the future generally of UK chains and the high street. If it's approved, turnover rents, I think we can probably expect to start to see that used much more frequently by the large-scale retail employees looking to follow suit and possibly considering themselves as a disadvantage if they don't. And that will really herald, I think, a longer-term agreement to turnover rents being a significant change to the status quo. This is in the context, of course, of 2020, where we've already seen the emergence of voluntary or enforced, to an extent, acts of kindness from landlords, with many accepting rent-free periods and rent deferments. And I think on the other flip side of that, and probably finally from me, Christina, if the current use of CVAs with turnover rent, as exemplified in the New Look case, is found to contravene the law, then this is likely, I suspect, to severely limit the use of CVAs in this context in the restructuring armoury going forward, when, of course, as I say, we're all aware that retail faces a significant challenge emerging out of the pandemic. So I hope that gives something of an overview of what I think the New Look case offers from a legal perspective.
That's great, Ben, thank you. Just remind the audience that we do have a Q&A function, so please, any questions. Those panelists not speaking will be happy to answer your questions in the background until we come to the end. But that's a great segue, Ben, to my next issue is, we had SEGA last year with the restructuring plan. And if we see landlords challenging CVAs, it's a question for Tom Poole QC, newly of Silk, so well done, Tom. Do we think this will lead to the growth of the use of the restructuring plan and the cram down of rights? And perhaps you want to talk about that in the context of Virgin Active, Tom.
Great, thanks, Christina. Morning, everyone. Well, I think there's probably two questions there, aren't there? Are we going to see more restructuring plans, and are we going to see the cramming down of rights? And a bit like Rowan's answer, both involve a bit of crystal ball gazing, as the new restructuring plan procedure has only been around since June last year. So natural result of that is that the case law is still at the very early stages of development. I think, though, it is inevitable that we're going to see parties looking to actively use the new restructuring plan procedure when circumstances permit. And I think that's for the simple reason that the increasing number of legal challenges brought by landlords against CVAs has created uncertainty around the process, as well as inevitable cost and delay. And I think whilst the case law that will be generated by the Regis case and the New Look case that Ben's just talked about will provide some clarity and potentially limit the scope of challenge, I think 2021 is likely, in my view, to see an exponential growth. Until the procedure has properly bedded in, there is inevitably going to be some calling out of its potential to be exploited. I think one view is that the increased use of restructuring plans should be seen as a positive development, because it gives directors faced with financial distress another tool when considering restructuring options. So as well as CVAs, directors will have the tried and tested scheme of arrangement or the new restructuring plan. Another view, and I think it's fair to say a view held by a number of landlords, is that the restructuring plan is another mechanism for large, highly leveraged tenants sitting on a load of rent arrears to extricate themselves from legally binding contracts. Now, I know everyone listening will be very familiar by now with the new restructuring plan, But just by way of a quick reminder, at first blush, the new process is very similar to a scheme of arrangement. So like the scheme, the restructuring plan sits in the Companies Act at Part 26A rather than the Insolvency Act. Both processes require members and creditors to be grouped into classes based on their rights. And then the classes vote on whether to accept the proposed plan or scheme. And in each case, final approval rests with the court. Probably the most notable feature of the restructuring plan is the introduction of the cram down mechanism. Now, again, as everyone knows, this is a concept that's borrowed from the US Chapter 11 process. And it was thought that its absence from the existing scheme was perceived as a weakness of that process. Now, in short, the ability to invoke a cram down gives a company with court approval the ability to potentially impose the plan even on dissenting classes of creditors or members that voted against the plan. And the court can approve such a plan provided that it's satisfied that, first, if the plan is sanctioned, no members of the dissenting classes would be any worse off than they would be in the event of a relevant alternative. And at least one class of creditors or members that would receive a payment or have a genuine economic interest in the company in the event of a relative alternative has voted in favour of the plan. Now, as we know from last year, looking at the case law, the restructuring plan has already been used by Virgin Atlantic as part of its broader recapitalisation plan, although there was no need for the cram down mechanism to be used in that case, as the plan was approved by all four classes of creditors. It wasn't until January of this year that we saw the first application of cram down by the court, and that was in the Deep Ocean case. Now, very briefly, three companies within the subgroup of the Deep Ocean group of companies proposed parallel restructuring plans in order to achieve a solvent wind down and avoid the negative impact of an insolvent liquidation on the rest of the group. Two of the three plans were approved by the requisite majority of creditors in each class, but in the third plan, whilst one of the two classes voted unanimously in favour, the requisite majority was narrowly not reached in the other class. And in that case, the court sanctioned all three restructuring plans. And if I were to set any homework, I would recommend everyone reading the judgment of Mr. Justice Trower that was handed down in the Deep Ocean case on the 28th of January this year. It provides an extremely helpful guide on the application of the cram down mechanism, which I fully expect to be followed in future cases. And I think whilst we're talking about restructuring plans, and before I come on to the Virgin Active case, it's probably worth mentioning one other case, which is a recent judgment of Mr. Justice Zaccaroli in Gate Group, and that was handed down on the 17th of February. And that was the first time that the court had to rule on whether a restructuring plan fell within the Lugano insolvency exclusion. And I think it's fair to say previously it had always been assumed that a restructuring plan would be outside the exclusion. However, Mr. Justice Zaccaroli held in the Gate Group case that a restructuring plan was an insolvency proceeding and therefore within the exception, the effect of that being that the English court had jurisdiction despite there being an exclusive jurisdiction clause in favour of the courts of Zurich. And now, finally, and not least, the Virgin Active case. So on the 1st of April, Mr. Justice Snowden handed down a judgment explaining his decision to convene class meetings of creditors for each of the three Virgin Active companies looking to implement a restructuring plan. Now, I think it's fair to say much of the decision is highly fact specific, but I would again recommend reading the convening judgment, which was the judgment handed down on the 1st of April. It provides a useful insight into how the court can balance commercial sensitivity and urgency while enabling creditors to make submissions at Part 26A hearings and also vote on an informed basis. I think one point to take away from that convening judgment worth noting is the fact that the adequacy of the explanatory statement was challenged on a number of fronts by an ad hoc group of institutional landlords. And I think, again, it's fair to say the court was broadly unsympathetic where the landlord sought confidential information that was not directly relevant to whether the proposed plans improved the landlord's return compared with the relevant alternative. However, the court indicated that the plan companies ought to disclose voluntarily, and obviously in return for confidentiality undertakings, their 5-year business plan and certain pre-pandemic financial information to the professional advisors of the landlords. The advisors could then provide summaries to their clients and potentially third parties, provided further confidentiality undertakings were provided. So I think, needless to say, if the plans are approved, the sanction hearing in that case promises to be a substantive and a highly contested event. So then, rather long-winded way, returning to the two questions, I think in answer to the first question, I do expect to see a greater use of the restructuring plan process by companies to compromise their pandemic debt rather than CVAs, for the very simple reason that the new process allows more dissenting creditors to be dragged along with the process than the CVA allows. As for cram-down, I do have some concerns that some IPs will avoid engaging with landlords by refusing to set up one of the ad hoc creditors committees that can be brought together under the restructuring plan. And the obvious risk you have there is that it will make it extremely difficult to come to consensual restructurings in the future by effectively seeing landlords being backed into a corner.
Thanks, Tom. I know there's concern about cost of the restructuring plans. And I had a request a couple of weeks ago. I can't find a precedent anywhere apart from going to Companies House and logging on, looking at the Verging Active one. I know that R3 is working with Alison Goldthorpe at Norton Rose Fulbright and LexisNexis to prepare an RP that's fit for SMEs. But are you aware of any precedent out there in the marketplace that the delegates might use? I'm
not, Christina, no. And as you say, other than going to Companies House, which is not the most convenient, at the moment, there isn't, as far as I'm aware, anything.
Okay, thanks, Tom. Okay, I've got a question now for Shams, if you'd like to join us, Shams.
Thanks, Christina.
Shams, you're a very creative and inventive lawyer who likes a fight. I don't have I'm shouting that out for you, but what alternative rights and remedies are there for landlords that you've been creating to overcome these obstacles?
Yeah, this, I mean, as a property litigator, this is the alternative remedies is something I've been extremely excited about in the last year or so. As my learned friends from Three Hare Court said, there has been a perception in times of COVID that there's little action that can be taken in relation to arrears, and that's it. You're stuck with a government moratorium, and good luck in the future. In fact, there are several options, in my experience, which could well be used against defaulting tenants. So, for example, even in terms of forfeiture and issues of rent arrears, the most important thing is to look at the timing, and you could challenge as a landlord, acting for landlords, we have successfully challenged arguments on waiver, because we've been able to argue that rental payments were made and there was no waiver. So those are technical points which are interesting. There are several other points. So there can be forfeiture for several other grounds which are not related to arrears. The starting point is the lease. That's the absolute starting point. You look for other breaches in the lease. Has the tenant been responsible for unlawfully assigning part of the premises? Has the tenant been responsible for unauthorized works without any license from the landlord? Importantly, are there dilapidations issues? I mean, in my experience, dilapidations is quite a big point, and one which often isn't taken by landlords, and to their detriment. So, for example, if one is looking ahead, it's a good idea to have an interim schedule of dilapidations, bring on board a good surveyor, have an interim schedule of dilapidations which crystallizes your claim. And it's far better to do that than wait until the end. If there's no terminal schedule, then the landlord can be left high and dry and stuck effectively. There are also other issues in terms of rent deposits and deeds of guarantee, which can be relied upon in terms of any enforcement action. And when it comes to lease renewals under the Landlord and Tenant Act 1954, again, in my experience, not enough landlords look at the tenant's breaches as a ground to resist an application for a renewal lease. And there has been recent case law which has addressed the balance somewhat. And what I would say is for landlords, be bold, look at alternative options, look at these other remedies, And if you have the evidence, if you have the surrounding evidence and other legal arguments, and it's definitely well worth a try, and it has been used successfully.
Thank you, Shams. Question for Ian. We're talking about alternative remedies. It seems to me there's an obvious one that we haven't covered today, and that's administration applications by creditors. Is there an appetite there? Have you seen that?
Yes, but the risk of being slightly contrary to a previous comment as well. Despite what Phil and I do, we actually don't want it to get too busy. For lots of selfish reasons, like we do lots of good book M&A as well, but actually on a personal level, we actually want to go to some of these businesses. We want value to still be there and businesses to survive. It will be better in the UK. So there is a balance with, but I do agree that we could see a small tsunami in due course. It's interesting listening to Rowan and Tom around where these are all going to evolve, but I think there is clearly a pent-up frustration by landlords in particular, especially where, and we all know who they are, the tenants that can pay but won't pay. But it's also not just creditors' applications for administrations, because there's another matter we're potentially looking at that could be a court-appointed receiver on the basis of just an equitable grounds, where a creditor's rights are being unduly, unfairly impinged. So I think there's a couple of other options in there. I recently acted for a landlord on a, let's call it a newsworthy front page situation where we actually signed the consents to act, and those was held in escrow, undated, and sent to the tenant and their advisors. If you don't do this and give us the information we want, we will appoint administrators. To which the answer was, oh, that's an abuse of the temporary provisions. And of course, the temporary provisions don't make any reference whatsoever to creditors' applications. Unfortunately, in that situation, and we were prepared to take the appointment because, interestingly, there was a guarantor structure as well, which actually was an owner of quite valuable assets elsewhere around the world. Unfortunately, the landlord hadn't explained all of their circumstances and backed down at the last minute. I suppose the analogy I used was, you don't threaten to hit somebody unless you're prepared to actually hit them. But I think there will be a growing desire and frustration, pending the outcome of the government consultation on CRA and the winding up petitions and how that unwinds. Landlords have got businesses too. Landlords have got their own bills to meet, their own demands and their capital stack. And there's a lot of pressure on their lenders behind their leverage as well. So I think that it should be a genuinely considered option where one isn't getting the information flow, where one isn't getting the seat at the table. And I can see that being, I would certainly be advising it in certain circumstances for certain. What I do find interesting is Scott's comments around rivals collaborating. We've seen this in the US where landlords are taking over shopping centres and things like that. We've seen it a little bit with Travelodge, where there was a breakaway, and clearly on Virgin Active as well, where some of the landlords were trying to take action. I personally would use it in the right circumstances. However, I do fear that most of the time, and it's probably the right answer, it's about advocating for any given landlord or group of landlords to get an early payment, to get a better outcome than they would have got if they'd have just sat quietly.
Thank you, Ian. Just go back, we had a poll actually on the question of fairness and morality, if I dare put that into context. Do we think it's fair to cram down proprietary rights? I think we've got a yes or no question for the audience.
No.
Just take a second. Interesting. That's 2/3. Thank you for that. I want to pause here and just mention the new role of the evaluator in administration. And I'd like to ask a question for Phil. Do you have confidence in the role of the evaluator? And will proper governance make this more attractive for businesses?
So yes, it's a very interesting point about the role of the evaluator. I'm part of kind of FRP's own kind of working party to try and work out our response. I would say the intention of the legislation was good. An insolvency practitioner should be confident that their commercial and professional decision to complete a pre-pack or post-pack with a connected party is the correct one. So it should be able to withstand the scrutiny of the third party. I think the question is whether its implementation in its current format is flawed. It really goes back to the issue that the cost of this process is one the purchaser has to bear. So there's no desire, as with the pre-pack pool, to pay for a substantive view of the decision, because clearly they're interested in having a yes. So we're probably going to be the same stage as we are with the current pre-pack pool, in that in order to keep the costs down, the whole process will be a black box, which will be you provide the papers into the pool, you have no control over who looks at it, what their qualification, skills or experience are, and you get a response but with no ability to kind of influence or discuss that response with the evaluator. Now, in practice, on smaller cases, the kind of 3 to 4 hours of time that fee will cover for the evaluator is probably fine and sufficient. It clearly won't work for the larger jobs. I mean, some of the larger jobs I used to deal with, you'll be hard pushed to be able to read the IBR report in the 3 to 4 hours, let alone form a view on whether it's a valid deal. I suppose the issue really with the evaluator is what is the government seeking to achieve here? Are they worried about the smaller businesses that undergo successive insolvencies? Or is it the perceived abuse of the process with larger ones? At the smaller end of the spectrum, I think the evaluator role, if it's managed through effectively the pre-pack pool approach, will probably work. For the larger ones, it will simply be another step on our checklist through on the path to effectively that agreed strategy. I'd say FRP's house view, which is in common with quite a lot of firms I've approached about how this is being used, is we will still carry on and transact regardless of a negative response, because we feel our in-house control and policies will ensure a sale of connected party is the correct one. And at the end of the day, it's my PI and it's my license on the line if I can transact. And frankly, somebody looking at my case for 3 to 4 hours is not likely to change my opinion on what I should be doing. So I think the interesting thing about whether this will make pre-packs more attractive will probably be driven a little bit by what happens with CVAs. If CVAs get harder, then the pre-packs may become much more the initial go-to tool. And that will really kind of drive if it's used. But I mean, at the moment, I think the way it's structured, it's really probably not going to make any real difference to the use of pre-packs, but may give a little bit more comfort, particularly at the smaller end, that at least somebody's had a look at it.
Lovely, thanks, Phil. You mentioned the future. I want to just explore that with the panelists. I mean, how will the future develop and how are we going to navigate going forwards? Perhaps, Scott, I can invite you to join us, please. But Scott, do you think there's still scope for consensual informal agreement with landlords? Is that still a viable option for an informal consensual agreement?
I think it definitely is, Christina. I think, let me just cite one particular example that all the ones I've been involved in the last 12 months or so, a number of which have been mentioned by the panelists today, but I think the best example of a consensual agreement being reached is Pret-a-Manger. So Pret-a-Manger is as we all know, a large business controlled by JAB, a massive German organization. They were a great business before the pandemic, and I'm sure they'll be a great business again. But unfortunately, because they had 440 stores in central London and very few in the regions, they were really hit by lack of tourism, hit by the travel in locations like Canary Wharf, and lack of office workers buying their sandwiches at lunchtime. So they went from an 86 million EBITDA last year pre-pandemic to a £200 million loss so far this year. So it's an absolute slam dunk CVA scenario. Unfortunately, it's technically insolvent. as a UK entity, and it would qualify in every single way. What they did, they were they're very professional, very sort of lovely people. They instructed a firm of restructuring advisors to provide a report about the validity of a CVA, and provided that report to all of their landlords. I think in total there was about 265 different sort of landlords out of the portfolio, to show them that the CVA was possible. But they wanted to reach a consensual agreement. They wanted to try and sort of show landlords that they didn't want the stigma attached to a CVA. They wanted to try and avoid it. They were able to do so, but would you please, Mr. Landlord, support us? And Christina, I must say that the vast majority of landlords, about 80% in total, have been extremely supportive and have ensured that that business has survived, and given them sort of either short-term relief or sort of restructuring relief. They were almost sort of presented with a case of, here's what you would get in a CVA, here was the outcome, but here's what we're offering you, a much better outcome if you accept a consensual sort of agreement. So that was an extremely successful process, and they saved £45 million in rent, and the business has, God willing, fingers crossed, survived. If I can go slightly just off piece, Christina, with one other hybrid example of what could happen if landlords hold out. There's definitely a horrible sort of momentum that's been driven during the pandemic of landlords thinking, do you know what, if I hold out here and I'm the last people to capitulate, maybe I might get a better deal. And I think Anne Summers is quite a good example of this. Anne Summers went through a consensual approach, very much as Pret a Manger did. Same scenario, went to all their landlords, 90 stores, and 84 of those landlords agreed during 12 months of negotiations a consensual agreement, and it was all documented and fine. However, 6 held out. Now, those 6 landlords thought they were being, smarty pants and having held out and sort of got a better deal as a consequence. But what the Anne Summers board decided to do in December the 21st last year was to put the business into CVA just to compromise those 6 landlords. And which I thought was an interesting way of approaching it. And many other institutional landlords were frustrated that their rivals were getting away with it. So they were almost quite appreciative of the Anne Summers approach, that those that hadn't collaborated, those that hadn't supported, were compromised.
Interesting, Scott. Thank you for that. A question from the landlord's perspective. I'm going to ask Shams to join us. Shams, why should landlords not benefit from future success of a business? Will we see the taking of equity stakes, or will there be a rebalancing with lease renewal rights, rent deposits, or protected tenancies? What's your opinion?
Really interesting question, Christina. I mean, CVAs would only impact on the existing lease obligation, so it'll be interesting to see what happens if new leases are granted. Turnover rent may be one way of achieving parity for the landlord and having that interest, but of course it's a double-edged sword in terms of which way those rents are heading. And in terms of equity release, equity stakes within the business, well, presumably that's not ideal for the landlord. Presumably there are already a number of where there are already a number of creditors. And there are already complex ownership structures. It's less than ideal for the landlord to try and carve its own ownership and equity within such a structure. And for that reason, I think landlords would much rather take the cash rather than equity, because, as has been said, landlords are running their own business. The other point is, of course, ultimately it's a question of the market and the location of the property, what future demand there is likely to be for that, will there be a change of use, and all of those factors which go into the mix in terms of the demand for that commercial property.
Super, thanks, Shams. I've got a poll for the audience in terms of the future. Do we see the future as being CVAs or restructuring plans? Where does your confidence lie? Great. RPs. Let's get a precedent out there we can all use and help our clients. I'd like to invite Phil really for the finale. and a couple of questions just to round up the discussion. Phil, how many CVAs are there left on the high street to do?
Oh,
And I'll leave you with that question first of all.
yeah. So, so we probably should have had a poll on that one, shouldn't we? Really, but I would say that, in my view, a lot of the formal restructurings have occurred. If you look back at the changes of government policy, obviously a lot of the CVAs and the restructures you're doing were tied up with when forfeiture relief would fall away, when wrongful trading protection relief would fall away. Now, a lot of the time, the government left those extensions to the last minute. So if you're looking at a CVA or going to propose a CVA, you need the time to call the meetings and get through the challenge period. So I think most of those formal restructurings have probably occurred. The real exception to that is really to do with those restructurings that are done right at the start of COVID. Most of those would probably be based on the assumption that there wouldn't be successive national lockdowns. And if you recall back, the government's original view was that they may implement further regional lockdowns, but would never do another national. So a lot of those businesses may have got their post-restructuring forecast too wrong. We've helped a number of businesses go back to their landlords, effectively trying to renegotiate terms again. A lot of the work we did was to try and agree kind of COVID guarantees with landlords. So effectively say, look, if there was additional lockdowns, or if it was a leisure business, or there were additional curfews, that there would be an immediate adjustment of the rent to try and build in that flexibility, given nobody really had an idea where the pandemic was going at that time. The other main issue which may drive these is really going to be what the position is going to be with HMRC, how aggressive they're going to be in trying to claw back the amount of effectively money they've left on the table with businesses. And secondly, particularly for the mid-market sizes, will the recovery loan fund do what the politicians say and provide that working capital which is needed to come back out of lockdown and to grow and develop and to kind of hopefully smooth the process back into a normal trading environment. So I think, subject to those two provisos, I think we've probably seen the swathe of the major restructurings on the high street.
It's a final question, Phil. Who will be the winners and who will be the losers?
Oh, so I think there's a couple of aspects of looking at this. One is, there's been at least £100 billion of additional savings by the population in the UK from the results of the lockdown. And really the winners will be the ones who get the biggest share of that money, if that's going to be spent. Obviously, we're dealing with Debenhams at the moment, so we get sight of quite a lot of the flash figures from other retailers. You can say probably from that first on the lockdown released week that, Primark, the main sports retailers, have been quite successful. And similarly, we can see that being driven by out-of-town shopping centres, probably from the ease of transport. In terms of who will be the winners, it's really going to be those that have embraced the pandemic as an opportunity for change. Those that have reduced their costs, aligned their cost base, and will be in a very good position to take advantage of what hopefully is a bounce back. Ones I think have been quite interesting is those businesses that have really closely looked at their product offering and their distribution channels. You've got things with Thorntons, giving up on the retail side and purely focusing on the wholesale and online market. You've got Halfords from quite major change and pivoting their business from cars to bikes, and that's been very successful for them. Other winners will really come from the creative destruction that's been caused by COVID. It's going to be far easier to launch a pop-up concept store at the moment, and you'll likely receive substantial landlord incentives to do so. There's probably broadly two philosophies really which will drive who's going to win out of this. There's obviously been a trend towards higher degrees of customization and enhanced service offerings, so businesses treating retail as more of an experience. And then you've got the ones that have gone towards the automation side of things. So everything back to like the Amazon self-service stores, can you take costs out to make you more competitive with the online market? Turning to the leisure sector, I mean, obviously, I dealt with Carluccio's. The heavy reduction in the sites held by multiple restaurant chains has thinned the competitive landscape. So those that survived should have more of a market to go for. And it also provides some interesting expansion project prospects for those with the right concept. There are some very good sites now available, which previously would have been very difficult, very expensive to acquire. Other issues which will really determine on the winners on this is, how much will the working from home movement continue? We gave some advice to a kind of a grab and go kind of food chain. Anyone in London would have almost certainly eaten them. Their forecasts going forward are predicting a hardcore kind of permanent 25% reduction in footfall. So who can actually pivot and change to reflect the changing environment? And the winners on that will likely be the delivery services. Online as a whole will be a winner, given the number of parcels that come to my door every day. I think I can certainly say that has been a success. I think it's probably fair to say that Ian and myself both expect to be quite busy in this future as the government support mechanisms and measures all fall away, and the finance measures kind of also reduce. The winners and losers, I mean, it's the losers I think we've already seen, and we've seen the session on that. There are some models that which still won't work, and maybe what the CVAs will be just a postponement of the inevitable. If we look at even the main clearers at the moment, their restructuring teams are ramping up, so that gives us a clear view that there's going to be issues on the horizon. But I mean, I'd end on this and saying, if anyone in the audience has any hints or tips on those for me to approach, please let me know afterwards. But I think there is opportunities from any situation like this. A business that's been able to capitalise, batten down the hatches to come out the other side will be successful, and there's more of a competitive landscape to go at.
Thank you, terrific, Phil. Can I ask all the panelists to join us on screen, please, just to conclude? And I've seen commentary recently about the call for the government to change legislation because of the unfairness. I've seen commentary that some tenants are being left out because they are solvent and not insolvent. In terms, I think it's about consensual discussions, about transparency. Would anybody like the last word? Ian, you've got your mic on.
I say it might be counterintuitive, and I said this before, but counterintuitive given that we're restructuring and insolvency practitioners. But consensual has to be the right way forward, because you end up with too much entrenchment that destroys value. And I'm doing quite a bit of work around the sort of leisure and fitness and hotel space at the moment. And you need patience, you need collaboration, or Phil and I will be even busier. Okay, and it doesn't. Where does the value come if people can't just have an open conversation where everybody walks away feeling slightly hurt, but fundamentally with the right deal? It is the right answer.
Thank you. I've got time for one question. As we've been discussing, the questions have been answered offline. There's one question from Jonathan Dunkley. For creditor administration applications, how can the proposed administrators be satisfied that the purpose has been, if the application is premised on a lack of information? Perhaps that's one for Ian. How do you satisfy yourself that the purpose can be achieved if there's a perceived lack of information on the application?
Well, when I say perceived lack of information, Jonathan, it was a lack of communication in the last 4 or 5 months of a breakdown in the communication lines, no clarity on where the relative parties stood, and an awful lot of rumours. But the business that we were talking about absolutely has a future, is a brand that everybody on this call will know. And in the purpose of the administration apart from obviously just trying to get a seat at the table and the communication flow going, there would be buyers lining up for that business. So the purpose, the statutory hierarchy, the statutory purpose would have been hopefully to rescue the company, but in reality there was a bit of an opaqueness to the landlord about what was going on. You know, so you know, we had absolutely no qualms whatsoever about achieving the statutory purposes.
Thank you, Ian. Well, I think we've reached the end of our allotted slot. I'd like to thank you all for a very informative and well-balanced debate. I hope the audience, you've all enjoyed it. You got something to take away and think about and apply to your daily practice. So thank you everyone for joining us, and we'll see you hopefully in the flesh next time.
Thank you, everybody.
Thank you.